let's take the example of Indian Council of Arbitration. Unless I go and as an ICA, if I don't go and participate in these world forums, in these disputes, how will the potential investors to India know that I exist and what is my approach?
Hi everyone, this is Bhumika Indulia and today we are joined by Mr. Arun Chawla, esteemed Director General ICA, a premier institution dedicated for promoting arbitration and effective dispute resolution mechanism in India. With decades of experience in arbitration and commercial law, Mr. Chawla has been instrumental in shaping India's arbitration landscape amidst rapid economic growth and globalization. Thank you, Mr. Chawla, for joining us today. And to begin with this conversation, I would request you to please share your journey so far with us.
Bhumika, this conversation is really important, and I compliment you for leading this kind of an initiative, because arbitration isn't just about law anymore. It's about how businesses build trust, how countries engage, and how economies grow. Coming to my journey in this area, I've had a long experience in the corporate world, working on the corporate, legal, and strategies which would actually grow the profit sector. Thereafter, I shifted to the non-profit sector, which is FICCI, and I have had a nearly 23 years of experience in FICCI.
That's great.
It culminated in my being the Director General of FICCI for 2 years, and this is where I actually worked with the state governments and the industry to promote sectors, to promote investments, and that is has been the journey in the FICCI. While I was holding the FICCI positions, I was also advising the Indian Council of Arbitration, which is an allied body of FICCI. And I think in the last 12 years, we've brought ICA to a limelight, to a situation where it is accepted as one of the premier bodies in institutional arbitration.
Right. Thank you so much, sir. Uh, your journey has been an inspiration for all of us, and I'm sure our viewers will enjoy this entire conversation. Coming back to talking about arbitration, arbitration is seen as an efficient and fair, but in a country shaped by hierarchy, how does it really level up playing the field between the big players and the small players?
I would say in a country like ours, where hierarchy, social or economic, can influence how disputes play out, institutional arbitration becomes a great equalizer. It gives both parties, big and small, the same rules, the same structure, and the same neutral forum. Coming to the Indian Council of Arbitration, uh, you talk about the Act. Section 18 makes sure both sides are treated equally, given a full opportunity to present their case, and over time, Supreme Court has reinforced this principle, especially in cases like Centrotrade versus Hindustan Copper, the significant Core 1 and Core 2 cases. Now, what's really encouraging is how the courts have clamped down on unilateral appointment of arbitrators. This is beginning 2015, where the act was changed. For instance, in Vistufine versus DMRC, the court made it clear that you can't have one party controlling the process by offering a limited panel or handpicking arbitrators. This has really helped level the field, especially the public sector contracts where power balance can be skewed. Now at ICA, we take this principle very seriously. We ensure that appointments are neutral, disclosures are made transparently, and the process stays rule-bound. Now that's the difference that the institutional arbitration makes. It replaces hierarchy with process and privilege with principle. So yes, when arbitration is done right, it doesn't matter how big or small the party is. The law treats everyone equally.
Thank you so much, sir. Thank you so much for putting it in such a clear words. Uh, there's a lot of conversation happening regarding diversity. Can you please tell me how is Indian Council of Arbitration is promoting diversity, be it gender, be it language or region, in its panels, and why does that matter?
Bhumika, that's a great question. At ICA, we've consciously built diversity into our structure. Take the instance of our governing body. It includes members from government, industry, associations like FICCI, and various public and private, national and regional sectors. This means every voice has a place at the table. Take our membership. We have over 7,000 members and a panel of 4,500 arbitrators across different professions: law, engineering, finance, shipping, uh, and many more. You will find former judges, senior advocates, chartered accountants, and even foreign nationals on our panel. 25% of our governing body and 30% of our arbitral tribunals include women.
That's amazing.
We've also created a dedicated forum for women arbitrators, aligning with India's commitment to SDG on gender equality.
That's great. That's great. I think many arbitral institution or many institution in this country can actually take an example of ICA in while talking about gender diversity. So, so how many Indian businesses talk about arbitration fatigue? It's getting expensive and slow. How is ICA helping ease that burden?
That's really a concern. At ICA, we've taken several steps to make arbitration more accessible, affordable, and efficient. Uh, Justice Dhulia, judge of the Supreme Court, had put it very well that arbitration has become a rich man's litigation. And that's exactly what we want to change at ICA. First, we've strengthened our emergency arbitration provisions. So if a party needs urgent relief before a tribunal is formed, they can get it quickly without running to court. Second, we've embraced virtual and hybrid hearings. That means no unnecessary travel, no long scheduling, delays, and parties from anywhere in India can participate easily. This has been a huge benefit, especially for small scale disputes. Third, our entire case management system is now digitally supported. That helps us track timelines, coordinate better, and keep cases moving smoothly. Another important point, our fee structure is fully aligned with Schedule 4 of the Arbitration Act. It's absolutely transparent, reasonable, and among the most economical in India and abroad. The last point I would like to emphasize is that we have 10 regional centers which make it easier for businesses to access arbitration locally, saving both time and cost. So at our mission in ICA is very simple: to make arbitration user-friendly. It shouldn't feel like litigation in disguise. We want it to go back to what it was meant to be: quick, fair, and practical.
Right. Do you think all these steps can actually change the mindset, which where we say that it's a rich man's business? So, do you think we can change the mindset? All these steps, are we moving forward in changing the mindset?
It's you asked a very important question. Mindset. Mindset is what we are actually trying to change, because arbitration is not just about rules and not just about what the act says. It's the mindset, it's the way we function. Uh, take the famous IBM Fujitsu case from the 80s. It started as a copyright dispute, uh, but through arbitration under the AAA, the parties found it creative, amicable settlement, and continue their collaboration. So arbitration is not just imposing an award; it's how the parties, come together, discuss in the private rooms before the arbitrator, and find a solution. So the mindset is gradually moving away from litigation.
There is a circular which came out. Do you think government is pro arbitration or pro mediation?
Well, there is something, a model which we call ARB-MED-ARB approach.
Yes.
It allows, even while the arbitration is on, it allows mediation to be conducted. Maybe not in the presence of the arbitrator, maybe it's somebody else can step in that, so that it can bring the parties together, bring their, where they can kind of discard their egos and come down to practicable solutions and explore settlement options. If that fails, of course, there is a provision in law that arbitration resumes. But it does give parties a chance to repair trust. So that is a very important thing which has happened in the recent past. And we've also, government has come out with the Mediation Act. And we have, even at ICA, we've introduced the mediation rules, where we give opportunities to the parties to settle amicably without going to the hard process of arbitration.
Right. Thank you so much. I think Mediation Act is yet to be enforced. It is not yet enforced. Enacted, yes.
Act is yes there. Only thing is that
Enforcement.
the elaborate rules have not been promulgated as yet, which
Right.
in fact the government has very consciously allowed the institutions to work out their own respective rules,
Right.
and see how they can push the
Mediation.
mediation.
Right,
Yeah.
right. Thank you so much. While we're talking so much about changing the mindset, changing arbitration mindset, there are a lot of arbitration weeks happening, and there is some criticism which is doing the rounds. Um, we just had amazing Delhi arbitration weekend, and now we are heading for Dubai arbitration week. That is London arbitration week. There is a Singapore convention. So, uh, and there is some sort of criticism which is there, that so many arbitration weeks and we are only giving cards. There is no sort of business coming. Do you think that there is no opportunity in these arbitration weeks, and it is not taking us, or these participations are not fruitful? Do you also think that way?
This criticism is valid and invalid.
Okay.
Valid because sometimes when people participate in these disputes week, they don't see any concrete outcome immediately. So they tend to feel that this is a waste of time. But I would say that they are valid on two fronts. One is that arbitration is not just about domestic dispute settlement. It's about settlement of international disputes.
Right.
And unless, let's take the example of Indian Council of Arbitration, unless I go and as an ICA, if I don't go and participate in these world forums, in these disputes week, how will the potential investors to India know that I exist and what is my approach? What is, not only that, the second most important thing that these disputes week allow is it allows a platform where perspectives can be exchanged about how arbitration should be conducted, what are the rules that should be allowed, what are the what are the best practices across the world. It's a surely a very enlightening situation where you come to know what is happening around the world on one front. So it's, as I said, it has both. It has advantages and disadvantages of
Everything
not
has,
giving
yes.
immediate outcomes, but in the long run, it's a very good thing.
Perfect. I think this is a correct answer for all the criticism which has been doing the rounds, because everything, if you see, has pros and cons. We just have to focus on the pros and not at most of the time focus on the cons. So I think arbitration community through these weeks have become so strong that we have become it's a great bond, that we know everyone, we are one as an arbitration community, which I don't think any other community, any other field is doing the same thing. Thank you so much for putting it so correctly. uh, in terms of going ahead, in terms of arbitration, can arbitration actually strengthen business relationships instead of breaking them apart?
Uh, that's I would say the answer is in the affirmative. Arbitration is not just about deciding who's right and who's wrong. When done thoughtfully, it can actually preserve business relationships, sometimes even improve them. And very in my previous your previous question, I was pointing out to a famous case of IBM Fujitsu case from the 80s. I mean, it started as a dispute, but the parties found a very beautiful way of coming to a amicable settlement, and they continued the collaboration. That's the power of constructive arbitration.
Hmm.
And it happens with us day in and day out at ICA, where the parties file, the claimant files a case against the respondent, and midway, they suddenly find a settlement, and that's it. I mean, sometimes with the help of the arbitrator, sometimes even without that, because they are brought face to face.
Right.
It's not impersonal, it's so personal. They're sitting in the room, they get an opportunity when the arbitration breaks for some time, they get an opportunity to talk to each other. So it's a way of, finding solutions to their disputes and continuing their collaboration.
When we talk about the solving disputes, do you think ICA is following strict timelines this way SIAC is doing, the way other arbitral institutions? Because we have always seen that in India, following the strict timelines is a bit of a challenge. Do you also feel that way?
You see, the legacy is litigation. So that litigation, where you can very frequently counter strategies of reaching a settlement or reaching a sort of a judgment, where the judge has to deliver a judgment. So the parties which are weak, they try to find ways and means of delaying the whole thing.
Right.
So the same thing is crept into arbitration. But the important part is that our act now lays down timelines,
Wonderful.
and we have to adhere to those timelines. So in a way, unless there is very little flexibility in the act about seeking extension of time, if the award is not given within those timelines, so the arbitrators have to stick to those timelines.
Right. While we are talking about act, there is a arbitration bill also which came. Can you point out one positive and one negative aspect of the bill, arbitration bill?
The one which is still pending,
Yes.
I would say one most important thing: the bills are going to lay down all the rules and regulations, but at the same time, we are not doing anything to change the mindset of people.
Right.
And the mindset is that the arbitration is absolutely different from litigation. So, who needs to be appointed as an arbitrator? The arbitrator needs to be from a legal background, but at the same time, can be anybody. Can be a chartered accountant, can be an engineer, can be anything. Now, how do we change that mindset that the parties appoint the right kind of arbitrators
Right.
and not just the judges. So this is something where the bill is lacking in introducing provisions that people having gone through some arbitration experience should get an opportunity to become arbitrators.
Does ICA appoints arbitrators which are not just judges? Because I believe there are countries there are arbitral institutions um, in foreign countries where they prefer to appoint even professors as an arbitrators. Do you think we are also going ahead with that mindset?
See, I'll be very frank. My arbitration panel includes many categories. It includes academicians, it includes chartered accountants, engineers, you have experts, other than judges, of course. But we have to go by the rule of party autonomy, which is the basic rule in the Arbitration Act. So the option is given to the parties to appoint arbitrators. It's not that I have to impose the arbitrators on them.
And we are still unable to change their mindset. We are still struggling with it. I was hoping that I can apply to be an arbitrator, but we are still unable to change the
You can
mindset.
certainly come on the panel.
Thank you so much. We are talking about virtual world. Now, virtual hearings have changed how disputes are argued. What new power dynamics or communication shifts have you noticed?
You see, virtual hearings have really transformed arbitration, especially in terms of accessibility. So people can actually attend hearings without flying from one state to another state, without flying from one place to another place. Uh, the logistics of staying in hotels and spending on logistics, all that has come down. So that today the parties can join from anywhere, which serves as, it's time and cost saving. So this is very important for any dispute settlement.
Right.
But very important sort of, I would say, very important role that virtual hearings plays, that in physical rooms, sometimes the presence of big legal teams or senior counsels, it's very overwhelming, and especially for smaller parties. Online, that imbalance reduces. The focus shifts to clarity, preparation, and the strength of the arguments, and not who's sitting across the table. So, uh, really, particularly when the pandemic hit, uh, ICA was one of the first in India to move online, and it worked beautifully. At least the first few hearings where the evidence is not being led or substantive arguments are not being made, then the arbitrators and the parties can actually
Yes.
come down and sort of keep having virtual hearings.
Right.
Yeah.
So, do you also face some issues or some problems in virtual hearings? Are there any lacunas also? Because we see in courts, they face a lot of issues while doing virtual hearings.
Well, one of the main issues is that connectivity issues.
Hmm.
Then cyber security. Sometimes it's harder to read body language as well,
Right.
which is very important,
Right.
I would say, in any um, alternate dispute resolution mechanisms. It's not that impersonal the way litigation is conducted. It's
Right.
not between the lawyer and the judge. It's between how the parties are behaving on the suggestions of the arbitrators, or how to sort of come about and find solutions. So yes, in a way, virtual hearings have democratized arbitration, but they made it more efficient and inclusive, especially for those who might earlier have shut out of the process. So it's both. And there are challenges which we have to overcome,
Right.
but it's given a boost to the connectivity
Right.
of the
Right.
people, of the disputants.
Also, the travel time and
Yeah.
everything, we are saving so much of time. And as we said that there will be pros and cons of coming up with something new, and we have to focus on the pros. Uh, how does arbitration serve as India's soft power tool in international trade and diplomacy, especially with BRICS and regional corridors?
Bhumika, the arbitration is today is more than a legal tool. Uh, it's actually a tool of diplomacy and global trust. And trust, as you know, is the foundation, the basis for any international trade, for any uh, relationship between the parties. A strong arbitration system uh, will reflect India's international institutional maturity. When global investors see that disputes can be resolved fairly and efficiently, it'll boost their confidence, not just in Indian law, but in India as a business partner. And every impartial award uh, and enforced smoothly will increase the chances of, will increase the confidence of the investors in coming down to India.
Where do you see arbitration after 5 years?
Starting from the lacuna of pendency of legal disputes in the courts. Arbitration has been found as an acceptable tool to resolve disputes quickly and efficiently. And our government, our Prime Minister are continuously telling the world that we have the soft power, we have the human capital, we have the systems, we have the procedures to conduct arbitration in the most economical and smooth manner. And so our aspiration is to become the hub of international arbitration. So as we are all moving towards that goal, I think 5 years is a long time. Much before that, we will see arbitration as a very important way of dispute settlement.
One last question, sir, that there are so many arbitral institutions at this moment. How is ICA doing things differently? Because being here as an arbitrator, it's been ages that they have been functioning since long now, and the kind of ethics they have been following, so everybody admires it. What do you think that why ICA is surviving? Is it because of the principles and ethics they have been following, or the policies and their rules, and the kind of what message do you want to say why ICA?
See, our strong point is that we are very transparent in our procedures, transparent in appointing arbitrators, transparent in how we sort of conduct on a day-to-day basis. Our case managers have a personal rapport with the parties, and our case managers have a track record of working for many years in the Indian Council of Arbitration. It's not that every second day you will find a change in the human capital. They're committed. And the second most important thing is we continuously, through the arbitration process, we try to, in a very soft manner, persuade the parties to come down to a mediated settlement, which is what makes us different from other institutions.
One last question, that if you have to give any message to our viewers, what would you like to say to them?
Bhumika, at the outset, I would like to thank you and, of course, your Bar Bulletin team for this thoughtful conversation. If there's one important thing that I would like to convey to the listeners, is to tell them that arbitration is not just a legal mechanism. It's a culture of fairness. It's about finding solutions, preserving relationships, and strengthening confidence in India's rule of law. And as India's oldest and the largest arbitral institution, We remain committed to that mission to make arbitration inclusive, efficient, and globally trusted.
Perfect.
And once again, thank you very much for a wonderful conversation. It's been a real pleasure to share these insights with you.
Thank you so much, sir. It was amazing having this
Thank you.
conversation with you.